Good day and welcome to another episode of Lunch and Learn. Up for discussion today is everything about spousal maintenance. We venture off a little bit from the child maintenance theme and we discuss maintenance specifically pertaining to spouses. So today, Karu Opperman will be joining us today and she'll be leading the presentation. And to give you an indication of what you can expect today for today's Lunch and Learn, we will be discussing the post-divorce, so after divorce support of spouses. So it happens after a divorce has been granted, and we'll be discussing, or Karu will be discussing the factors that the court would take into consideration when establishing and determining the amount of maintenance that needs to be paid to a spouse. We will talk about the earning capacities of the parties, as well as the clean break principle that is used commonly in divorce courts. We will also discuss what is the difference between token maintenance, what is rehabilitative maintenance, as well as the casta clause that we find in so many of these type of agreements, as well as the question of does subsequent marriages actually have an influence on spousal maintenance, and when does that happen, and how and when actually to apply for spousal maintenance. But then, without any further ado, before I hand over to Karu, just a short explanation of the structure of these type of lunch and learn seminars or webinars that we present. If you have registered on our website, www.lunchandlearn.org.za, you would have received a link. And with that link, you would find some pre-reading material. In this webinar, there is quite an extensive document pertaining to the pre-reading material where you can read up on what is specifically, the history on spousal maintenance and so forth. You would have a direct link to the webinar, of course, and then very important is the resource and templates tab that you could utilize. Now, we also compiled a complete handout, a very detailed handout, together with some case law on spousal maintenance, which you can download for future reference, and as well as the slides that we will be, or that Karu will be addressing throughout this webinar. If she makes reference to certain case law, that would all be found in the handout portion of the resource and templates tab on the website. So without further ado, I'll put Karu on the word so that she can explain to you how does spousal maintenance work.
Good day. You are joining us for another Lunch and Learn webinar. My name is Karu Opperman and I will be your speaker for today. You haven't seen my face that much on these webinars, but I am happy to present the topic today. So we will be discussing how does spousal maintenance work. Now these webinars have largely dealt with child maintenance, but now we will be reaching a little bit further and talking about spousal maintenance. Yes, we are talking about spousal maintenance, and spousal maintenance compared to child maintenance, which we've been speaking about, they are comparable in the sense that both aim to basically secure the basic needs of a person and aim to basically sustain their standard of living. But there is a very, very big difference when it comes to spousal maintenance, because with child maintenance, the duty to support a child rests on biological parents and it is a common law duty. Whereas in spousal maintenance, there is no common law right to maintenance, or no common law obligation which just arises when the circumstances indicate that there is a marriage. So that's where this reciprocal duty of support is very relevant, because a spousal maintenance claim is basically the product of a divorce, and which is a way that a marriage comes to an end. So basically, during the subsistence of a marriage, the parties will have a reciprocal duty of support between each other. Reciprocal meaning that it goes both ways, they have to support each other, and that is an invariable consequence of marriage. And it doesn't just extend to marriages, it goes further to civil unions as well. So therefore, obviously, when the marriage terminates, the issue of spousal maintenance becomes very relevant. And that is because this reciprocal duty of support ends between spouses, which might actually leave a spouse vulnerable and needing maintenance to continue to sustain their standard of living. Now, another thing about this post-divorce duty of support, or just the landscape of post-divorce support of spouses, is that spousal maintenance is limited to the sense that it can only be claimed between parties that have a recognized relationship between each other. So that means that you cannot claim for spousal maintenance after you've gotten divorced. You can only claim for spousal maintenance before or upon your divorce, because after the divorce is final, there is no longer a legally recognized relationship between the parties, and there's nothing you can rely on to prove that there was a duty support, because the parties are divorced. But this will be elaborated in a little bit more later down the line. Yes, and then also another interesting thing about spousal maintenance is that it can be enforced even after the death of the spouse, but it cannot be claimed if it wasn't agreed to during the divorce proceedings, which also kind of links up to what I said, that spousal maintenance cannot be claimed after the divorce. It has to be claimed simultaneously when the decree of divorce is issued, or before the divorce. Now, this will sound a little bit more repetitive, but as I previously said, there's no right to spousal maintenance. So you have to prove that you have an entitlement to spousal maintenance, and that basically hinges on the fact that you need to prove that you need to be maintained, you need to be supported, because you will be left vulnerable after the divorce. And this is basically determined by looking at the means and the needs of the parties in light of their earning capacities, because a need to be supported, it makes logical sense that a need to be supported will rest on the earning capacities of the parties. And then also the Divorce Act specifically provides that spousal maintenance, there's no right to spousal maintenance. It's an absolute discretion on the court's side, which means that the court can basically hear your case and it can decide whether or not to allow that claim. It can decide not to give you spousal maintenance, because you don't have a right to spousal maintenance unless you prove that you have a right to it as such. And then we will be discussing all of the different factors that are present, which courts will take into account when determining whether or not they should award a spousal maintenance claim. And these factors can actually also be used by the parties to kind of test the reasonableness of their application or of their claim, to see whether or not they would be likely in succeeding in a claim for spousal maintenance. Now, these factors, there are many factors, but just to list a few of them, you can see on the slide that the factors will include, for example, things such as the existing and prospective means of the parties, their earning capacities, the clean break principle, and rehabilitative maintenance, which we'll be discussing in just a few minutes. And then thirdly, the financial means of the parties. the duration of the marriage, standard of living before divorce or during the subsistence of the marriage, the age of the parties, and then also things such as conduct, which might have been misconduct, leading to the breakdown of the marriage. But from the pre-reading material, you will also have seen or read that this might not be a decisive factor, as we don't have a divorce law in South Africa which is fault-based anymore. So that is a questionable factor, but it is nonetheless included. And then eighthly is also a factor which has a bearing on whether or not a court will award a spousal maintenance claim, and that is the order for the division of assets in terms of Section 7 of the Divorce Act. And then token maintenance will also be a factor, which will also be discussed in a subsequent slide. And then also whether or not one spouse gave assistance to the other spouse in materially building that other spouse's estate, while the spouse who actually helped might have been left without an estate that hasn't grown. And then additional factors will include, for example, things, I mean, that's the whole point. There is no closed list of things that the court will consider. There are things that the court must consider, but there isn't a closed list of things that are decisive. But other factors can include, for example, the best interest of the children involved, whether or not the dependent spouse or the spouse who allegedly needs support has a child care responsibility, whether they have a dependent child living with them. The inflation rate can obviously also play a factor. The manner in which each party portrays their financial position or gives evidence can also play a big factor. And that's similar to the conduct leading down to the breakdown of the marriage, because questionable conduct on the side of a party can definitely play a factor. And once again, just to show you the absolute discretion of the court in this, another factor that the court can take into account is anything that it deems fair and just, which basically just shows that there is really no closed list that the court must take into account. It must take into account all of the circumstances, as many of the financial I can't think of the word, as many of the financial statements and just things that give an indication as to the reason why the spouse is approaching the court is helpful, and it will be considered. So that's why it's important for applicants to know that they can go to court and they can explain the entire situation, because the court will only understand more and be able to actually get an understanding of all of the circumstances and the facts. Now, I've mentioned the earning capacities of the parties, and this is one of the biggest factors that will often be actually a decisive factor, because it makes sense that spousal maintenance depends on a party who basically lacks in earning capacity. They cannot go out and work, so therefore they claim spousal maintenance, because upon their divorce, they are left with little resources and they can't go out to find a job, for example. So the earning capacities is of crucial importance when applicants apply for spousal maintenance. And this also ties into the fact that courts are reluctant to give out orders that are uneconomical or just unreasonable. And this will also be discussed in a following slide, where we talk about the clean break principle, which is an idea which has crystallized in South African law, in divorce and family law specifically. And it's very relevant when we talk about the earning capacities of the parties, and when a claim is unreasonable or uneconomical, in light of the fact that this clean break principle exists. So yes, basically, just to quickly summarize, the clean break principle basically states that we, after divorce, we strive to see the parties as economically independent. We want to keep them as that after the divorce as much as possible. So therefore, the courts wouldn't generally just award a spousal maintenance claim if there's not good reason for it. But, for example, when a spouse that just does not have the capacity to be able to get a job because they do not have the resources, they have not had the training, and the clean break principle does not favor them succeeding with a spousal maintenance claim, they can also always apply for rehabilitative maintenance, which basically allows a party in need of support to rehabilitate themselves, to be able to go out and find a job. So that is basically maintenance for the time being, while the party who needs support is going out and getting the training and the skills they need to be able to go out and get a job and increase their earning capacity as such. So the relevant factors when a court will determine the earning capacities of the parties will include things, for example, such as the age of the parties, their respective qualifications, which also makes sense because the more qualified you are, generally the higher your earning capacity is, your employment status, and then also the number of dependent children, which also links up to the previous factors mentioned, which just shows how broad these factors really are, or these considerations in spousal maintenance. And then we get to an actual definition of the clean break principle. So here you can see that it is defined as striving for economic independence between parties post-divorce. And that basically translates into the fact that a court does not want to have to bother with enforcing all of these different orders between parties after the divorce, because they are seen as economic individuals and they shouldn't be then still seen as an entity together, and that's why it doesn't really make sense to award uneconomic spousal maintenance claims where the parties should actually, after getting divorced, just try their best to be on their own financially as well. And that basically just summarizes the rationale for this clean break principle, because it literally guards against the awarding of unnecessary and uneconomical spousal maintenance awards. So ultimately, however, spousal maintenance is still decided on a case-to-case basis. And we might have this principle in our law, but it does not mean that it is decisive. It does not mean that it will bar a party from applying for spousal maintenance if they've proven sufficient reasons and good cause as such. So ultimately, it will still be determined on a case-to-case basis and based on all of the previous factors mentioned. And then we get to token maintenance. Now, token maintenance is something unique to spousal maintenance in the sense that it's not really seen in child maintenance applications, but it basically can be defined as nominal maintenance, which is when you allow somebody a spousal maintenance order or award of a nominal amount, purely just to be able to allow them to, in future, if they need, to approach the court to have that order varied. Now, what is meant by a nominal maintenance amount is literally just an arbitrary amount. It can be R1, it can be 50 cents, it can be 100 Rand. It really doesn't matter. It's any small amount of spousal maintenance awarded purely for the reason to have a spousal maintenance order in place. And that basically allows you to then later, if you need actual spousal maintenance, you can go to court and you can apply to have that varied and increased. Now, yes, so I've spoken about the R1 example. So for example, again, if you have gotten divorced in the High Court and you have been awarded a spousal maintenance claim upon your decree of divorce or in your decree of divorce, then that basically allows you to approach a maintenance court. Now, take note, I've said that you get divorced in the High Court, which is generally what happens. Like, I believe it's possible in the regional court as well. But the problem is that you cannot apply to the High Court or to the relevant court where you got divorced to vary your maintenance order if there wasn't a maintenance order given to you upon your divorce. So therefore, it basically allows the jurisdiction token maintenance awarded in the High Court basically allows the maintenance court's jurisdiction after the fact. So if an applicant then later wants to increase that maintenance, then they don't have to approach the court where they got divorced. They can approach the maintenance court, whereas you cannot approach the maintenance court to actually apply for spousal maintenance in the first place. You can only apply to have your spousal maintenance varied if it's a form of token maintenance, which basically allows maintenance court jurisdiction in that sense. And then we get to another interesting thing that we frequently see in spousal maintenance applications and just cases in general, and that is called a casta clause. Now, you can see again, it's defined here. It is a clause with effect to forfeit maintenance if the recipient spouse does not lead a chastity life or enter into a subsequent relationship. So that basically means that if this clause is included in your spousal maintenance award, whether it be just an award based on an interim maintenance application, or whether it's included in your decree of divorce, a casta clause will basically mean that when the recipient of the spousal maintenance enters into a further relationship, it can be specified, obviously, if it can be specified that if the recipient does not lead a life of chastity, or if they just move in with somebody or enter into a subsequent marriage, for example, that clause will then basically operate to the fact that the maintenance receiver will no longer actually receive that maintenance because according to the specific term included, it would cease upon those conditions. And these clauses can be quite controversial because it does dictate to somebody else what they can and cannot do, which can be quite tricky. So it must be very, very clear when parties want to include a clause like this. And a court will not likely read this in. Court will not infer that parties intended such a clause, and it has to be very, very expressly included before a court will actually give effect to it. But even if it is included, parties have to be very, very careful with the wording they use, because these types of clauses can actually be seen as contra bones mores, and that basically means against public policy. And when a contractual clause is against public policy, it's rendered unenforceable. So applicants must just be very, very sure in the wording of such a clause. And then also, why would you include such a clause in the first place? I mean, I guess it does make sense, because if you are supported by this new relationship, then it justifies the suspended or the deletion, or the cancellation of that previous duty of support, because it's basically this idea against double compensation. If you are supported from one source, then you shouldn't have to be also supported from another source. It amounts to double benefit. And then this actually perfectly links up, because there is a difference in parties that enter into subsequent marriages, or that just move into another house with somebody, or that just cohabit with another person. So usually a subsequent marriage will entitle the maintenance payer to apply for either a suspension or termination of the maintenance agreement, because there is this double support, like I just said. The party who receives the spousal maintenance will actually benefit twice if they are supported by their ex-spouse and by this new spouse. And then also, obviously, this duty of support is an invariable consequence of marriage. So when you divorce, initially, duty of support ceases, it completely stops. And then when you remarry, it actually creates a new duty of support, which means that there cannot be a previous duty of support. But that does not mean, and this is very important, that does not mean that people can just stop paying spousal maintenance if it is included in the divorce decree or just in a separate agreement. Because if it is included in a contractual agreement, and it does state that it has to run out for a certain time, then before that time, before that contract is not fulfilled, you cannot just breach it by not paying anymore. You have to fulfill the contract, and then after that, upon remarriage of the spouse who receives spousal maintenance, then you will be able to apply to suspend or terminate. But it does not mean that you can just stop and be in breach of contract as such. And then there are different ways that maintenance agreements can be structured. And usually if there's no duration stated, like I just said, then you would assume that the previous duty of support arising from the previous marriage, which would then continue throughout the spousal maintenance order, will cease upon the creation of a new duty of support between the spouses in this new marriage. And then also, obviously, if you include a casta clause to the effect that the maintenance obligation will cease upon remarriage or cohabitation, it can then indeed actually cease, and there's no need to apply, like I just said. But then it will have to be specifically mentioned. Now, there are various times in which you can apply for spousal maintenance, but it is ultimately, and if there's one thing you take away from this webinar, it's that you cannot claim for spousal maintenance after divorce, after the divorce has been finalized. You can only claim for it before the divorce has been finalized or pending the divorce. And you obviously again need to prove that you have an entitlement to spousal maintenance. So you will have to prove your needs and means. Needs being what you need, why you can't support yourself, and these needs are things that your means cannot cover. So means would be then the financial resources that you can use to your disposal. But then there are also just a little bit more practical indicators of whether or not you'll be successful in your application. And this basically just puts the previously mentioned factors into a little bit more of a real life context. So, for example, indicators of likely success, things that would basically help you in your application, and that would basically most likely the court will allow or will award a spousal maintenance claim in these contexts. So that would be, for example, where you have little or no estate built up during the subsistence of the marriage, and therefore left with little or no estate after the marriage as well. Also, a lower earning capacity. We've already spoken about that. Age and just being older definitely counts in your favor, because the older the age, the less capacity to work generally, and that might count in your favor. But then also, again, as previously mentioned, the assistance given by one spouse to build the other spouse's estate. That might also be an indication that you might require spousal maintenance, because you have not been able to work on your own estate. You've been assisting the other spouse, building their estate. And that's typically what happens in the context of a couple, and then one of these spouses maybe becomes a celebrity, maybe gains some attention, some public attention, and then the estate grows as such. And maybe the other spouse helped them in reaching that stage, just as an example. And then on the opposite side of the successfulness spectrum, you can see that you will most likely not succeed with a claim for spousal maintenance if your claim is excessive. Obviously, that speaks to the clean break principle again, and that an uneconomical claim will not be entertained by the court. So, for example, also, even if your claim is excessive, but also if you claim the wrong things from your marriage, if you claim the excessive cost of living expenses, then it might be seen as unreasonable. And again, also the party's misconduct might also play a role. Their ability to work, if they do not have the ability, or actually more, I want to change it and say the willingness to work. If an applicant does not show willingness to go out and to go work and to get the skills to be able to get a job, the court will most likely not entertain their application for spousal maintenance, because they aren't even trying. They are just unwilling to work. And also unreasonable claims, as I've spoken previously. I think that does make sense. And then just on how to actually apply for spousal maintenance. And you can see I refer here specifically against the living estate, because you can actually claim maintenance from a deceased estate or from a spouse's deceased estate. But this will not be discussed in this webinar. And we will definitely have future webinars on these topics, however. And that's also relevant for cohabitees who can claim in terms of the Maintenance of Surviving Spouses Act and the Intestate Succession Act. But now, how to apply for spousal maintenance? Now, once again, there are two different contexts in which this can take place. It can either take place pending divorce or upon divorce. Now, Upon divorce, I want to say more, it's simultaneously when the divorce decree is awarded. It's before the divorce is final, but it's almost even more simultaneously with when the divorce is finalized. And that would usually be done in a regional court, in a divorce court, or in the high court. But, and as I said previously as well, regarding the issue of token maintenance and this whole jurisdictional conundrum, if you were divorced in a divorce court, a regional divorce court, or the high court, and you were not awarded a spousal maintenance amount, that does not, you cannot then, after the fact, claim for spousal maintenance. And that's a very, very crucial fact that I've been trying to highlight the whole time. So to circumvent that, we have this thing called token maintenance, as previously discussed, which basically solves this whole issue, because where you were divorced, that court will then basically give its jurisdiction regarding these matters to the maintenance court if it issues or if it allows and awards a token maintenance claim of, for example, R1, just to be able to say that maintenance is covered in your divorce decree, and that you can then later, you do not have to approach the same court that you were divorced in, you do not have to approach the high court. You can then, if token maintenance was granted, you can approach the maintenance court to enforce your spousal maintenance application, which means that if the respondent is in arrears, you can apply to the maintenance court for the relevant remedies, which is very, very useful. And then we can also claim for spousal maintenance pending divorce. Now, I've spoken about the issuing or the granting of spousal maintenance simultaneous with the actual divorce, but you can also claim it before the divorce, when you can see that the circumstances are indicating that the divorce is going to be drawn out, it's going to be delayed, it's going to take long, and it's going to cost a lot of time and money. That basically allows a vulnerable spouse to apply for interim maintenance while the divorce proceedings are still going on, while the divorce proceedings are still drawn out. And that you do by way of filing a Rule 43 application in the High Court or a Rule 58 application in the Regional Magistrates Court, which you will then basically initiate by a notice of motion and relevant supporting affidavits. Just to detail all of your reasons for needing spousal maintenance, and basically just setting up the context so that the court can understand the circumstances and make a correct determination based on all of the considerations that I mentioned. And then I believe we have almost reached the end. We will now be just going to have a discussion with Mr. Eugene Opperman, who is a family law practitioner who is very well educated in this field and can definitely answer a few interesting burning questions that I have.
Right, so I'll be joining in the discussion portion of this webinar, and we've received some questions via email that I would like to address. And first of all, that I would like to reiterate is that spousal maintenance is maintenance that is usually granted only after a divorce or during a divorce process. That cannot be stressed enough. You cannot, if you are already divorced, go to the maintenance court or even the high court to apply for spousal maintenance. Maintenance forms part and parcel of a divorce order or during a divorce process, where the court would look to certain factors and then grant spousal maintenance. And the reason for that is that the reciprocal duty between spouses would come to an end when the degree of divorce is granted by court. So by that time, there is no reciprocal duty of maintenance between the parties, unless the parties otherwise agree or the court makes an order to that effect. That is just something that I would like to bring to the attention to the listeners, and that is something that should not be forgotten. In the same instance, if you do have a spousal maintenance order, or order for spousal maintenance, even if it's done in the High Court, it could be enforced through the maintenance courts. The maintenance courts would definitely have jurisdiction to hear those type of matters. So if the respondent is in arrears with his maintenance payments, then yes, you could approach the maintenance court in order to enforce that order. A question that came through was, I am married according to a legally unrecognized Muslim rights. Can I claim spousal maintenance even if my marriage is not registered or recognized? Now, that is a question that pops up quite often, specifically in the Muslim communities. And if one looks at the case law, and I'm referring to the case of Khan versus Khan, the court actually held that partners or couples to a Muslim marriage that were married according to Muslim rights are entitled to post-divorce maintenance. So with other words, they are entitled to spousal maintenance. That means that all Muslim marriages, whether they are you married only with one person or two people, then they are entitled. It falls within the ambit of the act, and you would be able to claim for maintenance. And that was similarly also confirmed in a case of AMOD versus Multilateral Motor Vehicle Accident Fund, where the court also recognized Muslim marriages where they could claim for spousal maintenance afterwards. That was a question that was posed by one of our attendees that mailed me the question. The next question that they sent through was, can I claim spousal maintenance even if we were never married or in a civil union marriage? With other words, can cohabitees of people living together, can they claim for spousal maintenance? The answer thereto is absolutely no. Spousal maintenance pertains to exactly what it says, to spouses, which in effect means that they had to be married to one another, or they have to be married to one another. So there may be instances, as Carl might have mentioned, where there's a duty of support derived from sources other than the common law. But the common law of support, you know what, if there's children, if the cohabitees or people not married have children together, then surely yes, in terms of child maintenance, there would be a common law right for maintenance, but that would be maintenance for the child, but not for spousal maintenance. So if people are not married, then they are not allowed to claim for spousal maintenance. Interestingly enough, that was also a question that I dealt with probably a couple of days ago in court, was that if the parties are still married, they are not busy with a divorce process, and they have not even considered instituting proceedings in terms of the Divorce Act. Is the mother, is the applicant, can she apply for spousal maintenance while the parties are still married? And the answer there to is absolutely yes. Even if the parties have no intention to divorce, if the respondent or the father is not looking after the children, then yes, you could apply to court for in terms of spousal maintenance that could be claimed. So that is definitely also available as a remedy. The next question is, can spousal maintenance be paid in a lump sum, or must it be paid via monthly installments? Now, under the previous act, under the previous Maintenance Act, they did not regard a lump sum, a one-time payment, once-off payment, as spousal maintenance. That has subsequently been changed under the new 1998 Magistrate Act, where it allows for payments in a lump sum instead of payments just on a monthly basis. But usually what we find is in divorce contracts on consent papers or settlement papers are that usually there is either one or two stipulations. The one stipulation would be that spousal maintenance would only be payable for a certain period of time. Say, for instance, it's payable for 36 months, whereafter it would lapse. Or it would be payable up until the death or the remarriage of the other spouse, and then it would lapse. So those are the two scenarios, and that amount could be paid out as a lump sum. And that is basically the two questions that we have time for. We thank you so much. I thank you for Caro for joining us today for doing the presentation on spousal maintenance. If you have any queries, you're most welcome to drop us an email on info@lunchandlearn.org.za, or if you just want to tell us if you like the presentation, or if you would change something, or if you just have a general question regarding maintenance or spousal maintenance, you're more than welcome to drop us a mail. My name is Eugene Opperman. I'm a family law practitioner. I've been practicing family law for the past 23 years, specifically in maintenance law, domestic violence law, and law pertaining to children's rights. Yes, we thank you for joining us today. Once again, thank you for Caro for the detailed presentation, as well as the handout that she so adequately made available for us for download. So we'll see you guys next week, same time, same place, and have a good evening further.